Good morning, everyone. The House Judiciary Committee will come to order. Will the Secretary please call the roll?
Chairman Briggs.
Here.
Representatives Abney,
Designation.
Carroll,
Designation.
Donahue,
Designation.
Hanbidge,
Designation.
Hohenstein, Howard,
Online. Designation.
Kenyatta, Kincaid, Mays,
Designation.
Piele, Rabb,
Designation.
Sanchez, Schusterman,
Online. Designation.
Chairman Kaufman,
Here.
Representatives Bonner,
Designation.
Borowitz, Ham,
Here.
Kale, Kerwin, Clunk, Kuzma,
Designation.
Ledbetter,
Designation.
Pugh, Rigby,
Designation.
Shalaba.
Designation.
Mr. Chairman, a quorum is present.
Thank you. Having a quorum, we will proceed with today's agenda. But before we do that, before we meet, too many times in the past couple years, we've had to have this conversation. I'd like to open our meeting with a moment of silence to recognize the heroism of one of our finest. On Sunday, March 8th, State Trooper Corporal Timothy O'Connor was shot and killed in the line of duty in Chester County. He is survived by his wife, Casey, and a young daughter. The Commonwealth, the General Assembly, and the House Judiciary Committee honor Corporal O'Connor's heroism and service. We send our sincere gratitude, thoughts, and prayers to the O'Connor family and the brave troopers with the Pennsylvania State Police. You can stay in your seats, but if you would join me in honoring Corporal O'Connor with a moment of silence. Thank you very much. First, just so everyone knows, we do have a QR code. We are continuing to follow the speaker's wishes and going paperless. So the agenda, we have a couple hard copies, but the agenda is spread out through the room using the QR code. First on the agenda, I will be calling up House Bill 300, introduced by Representatives Kenyatta and Benham. The chair will recognize both Representative Kenyatta and Benham for brief remarks on the bill. Representative Kenyatta, you are in order, and then Representative Benham can follow. Representative Benham? If you could go to the main table in front, thank you. You're in order, Representative.
Thank you, Chair Briggs and Chair Kaufman, for taking the time to consider this bill this morning. Passing the Pennsylvania Fairness Act will provide long-needed protection and affirmation to our communities who have for so long fought to be recognized, accepted, and protected by the Commonwealth. As a member of the LGBTQ+ community myself, this issue is personal for me and feels especially important at this moment in history. The passage of this bill would be another step in ensuring that every Pennsylvanian is treated with dignity and respect. This legislation simply extends these protections that are already granted to individuals on the basis of sex, religion, or national origin, and does so only in the areas of employment, housing, education, and access to public accommodations. Despite the misconceptions that some seem to hold, this bill creates no new rights. The idea that we do not deserve to be discriminated against because of who we are or who we love should not be seen as controversial. We understand, and most Pennsylvanians believe, that our Commonwealth is better when it's fairer. HB 300 ensures a fairer and more equal future for all of us. So thank you to the chairs and the members of the committee. I encourage a yes vote.
Thank you, Representative Benham. Representative Kenyatta, anything you'd like to add?
Thank you so much, Mr. Chairman, and thank you to to the committee for consideration of House Bill 300. So I want to be very clear about this morning what this bill is about and what this bill is not about. House Bill 300, the Fairness Act, at its core is about us as a legislature advancing Pennsylvanians and Pennsylvania's most core values of being a welcoming place. In fact, the story of Pennsylvania begins with a boat called Welcome that brought 2,000 folks who would settle on this land and start an incredible experiment in self-governance and an incredible representation of what that self-governance can look like at its best here in the Commonwealth of Pennsylvania. As Representative Benham mentioned, this bill is very simple in that it crystallizes and puts into statute a basic principle that Pennsylvania is better when it is fairer. That we must live and that we can live in a Commonwealth where nobody gets treated like crap because of who they are or who they love or what they look like or where they're from. And if people do have to experience the venomous bite of discrimination, we're allowing folks to have a process where they can share what happened and go through the same process that everybody else goes through in Pennsylvania when they're treated differently because of who they are. And we want to make sure those protections include everybody, that every single person is welcome in the Commonwealth of Pennsylvania. Now, let me be clear what this bill is not about. This bill is not about sports. Love sports. I'm an obsessive, obnoxious Eagles fan, and I make no bones about it. This bill is not about that. So I understand in advance that that might be brought up in this debate today, Mr. Chairman. But you can bring it up, you can say it softly, you can say it loudly, you can tweet about it after. This is not in the bill, has nothing to do with the bill. So if your argument today is that you care about women in sports, you know what, so do I, and this has nothing to do with the bill. If you want to talk about bathrooms, this has nothing to do with the bill. Nothing to do with the bill. Go wash your hands when you leave, but that's not in the bill. If you want to talk about your faith and my Christian faith, we can have that conversation. But you know what? What I learned growing up and what my faith teaches me is that we have a responsibility to welcome the stranger, that we have a responsibility to treat our neighbor as we would treat ourselves, and that we have a responsibility as government to ensure that in the great Commonwealth of Pennsylvania, in this beautiful experiment that started with a boat called Welcome, that we continue to extend that welcoming spirit to everybody, that everybody in Pennsylvania gets to be treated fairly, and that in the cruel instances where people are not treated fairly, that folks have a process that they can go through with the Pennsylvania Human Relations Commissions. That is what this legislation does. We passed this legislation last session with bipartisan support. I hope that we can pass this legislation this session with bipartisan support. And you know what? As much as I'm sure Representative Frankel has loved seeing House Bill 300 introduced for 20 plus years, I'd love to allow that bill number to go to something else, another worthy piece of legislation, and get this bill, House Bill 300, to the governor's desk, who's made clear he will sign it without delay. So I want to thank you again, Mr. Chairman, for your consideration in this committee, and look forward to an affirmative vote on this legislation this morning. Thank you.
Thank you, Representative. Council, is there anything to add on the bill?
Thank you, Mr. Chairman. House Bill 300 amends the Human Relations Act to prohibit discrimination in employment, housing, and public accommodations based on a person's actual or perceived sexual orientation, gender identity, or gender expression. Employers are not required to construct new or additional facilities, and employers are explicitly permitted to require reasonable dress or grooming standards during work hours. Discrimination is permissible in the context of room rentals in a personal residence in which common living areas are shared and in single-sex dormitories. Lastly, the bill establishes a new section clarifying that nothing in the Human Relations Act shall be interpreted to require an individual or religious entity to engage in conduct that constitutes a substantial burden on the free exercise of religion. This bill takes effect in 30 days, and there are no amendments. Thank you, Mr. Chairman.
Thank you, counsel. The question is, will the committee report the bill? For folks online, we're joined by Representatives Carroll and Representative Ledbetter since the roll call. Just raise your hand if you have any comments. Folks here, are there any comments on the bill? I'm going to recognize Chairman Kaufman.
Thank you, Mr. Chairman. And I do also note that Representative Bonner has joined online since the roll call. Specifically on House Bill 300, I want to note at the outset that I fully agree that all Pennsylvanians deserve to be treated with dignity and respect. Our laws rightfully prohibit discrimination on the basis of race, religion, national origin, sex, and more. Those protections, they matter. They're rooted in the principle that every individual is created equal and entitled to equal protection under the law. Unfortunately, good intentions do not necessarily produce good legislation. This bill does far more than reinforce equal treatment. It substantially rewrites the Human Relations Act in ways that create serious legal, constitutional, and practical consequences for employers, schools, faith-based institutions, and families across the Commonwealth. We are told this bill is about fairness, but fairness cuts both ways. What about fairness to women and girls in athletic competitions? Decades of legal and cultural progress were built upon recognizing a basic biological reality. Men and women are physiologically different. That reality is precisely the reason why women's sports exist. When biological males compete in female divisions, the competitive landscape changes dramatically. In recent years, we've witnessed records fall, scholarships shift, and opportunities narrow. Last year, the University of Pennsylvania sent personalized letters of apology to all of the female swimmers who were forced unfairly to compete against a biological man. What about privacy in restrooms, locker rooms, and even domestic violence shelters? Separate facilities for the two sexes were not created to demean or discriminate against anyone. They were created in recognition of the inherent biological differences between men and women and to protect privacy, dignity, and safety in intimate settings. For generations, our laws have recognized that sex-separated facilities are reasonable, lawful, and appropriate precisely because biological differences matter in these contexts. Parents don't want men in locker rooms with their daughters, not because of hatred or bigotry, but out of a basic instinct to protect their daughter's privacy and dignity in spaces where people are undressed and inherently more vulnerable. Is a man's simple claim to be a woman without more sufficient to establish standing under this bill? Under the bill's broadly worded definition of gender identity or expression, the answer appears to be yes. This should concern all of us. It's also important to keep in mind that in today's cultural landscape, we are not dealing with two clearly defined categories. There are now dozens, if not hundreds, of gender identities that have been invented, many of which are fluid, evolving, or entirely self-defined. By refusing to ground the law in objective biological distinctions, this bill effectively creates a protected category with unlimited scope. Moreover, if we are going to base civil rights protections on self-identification alone, we must confront much broader implications. If a 20-year-old self-identifies as 70, Is he entitled to protections afforded to senior citizens? Could he demand access to age-restricted benefits, housing, or senior discounts? If denied, would that constitute age discrimination? If a white man identifies as black, is he entitled to claim protections based on race? If an institution declines to recognize that self-identification has it engaged in racial discrimination? If a man identifies as disabled without a medically recognized impairment, is he entitled to accommodations? If an employer questions that assertion, is it discrimination? If not, why not? Why is self-identification sufficient in one protected class but not in others? Why would we treat sex and gender differently from age, race, or disability, each of which has been historically understood as grounded in objective characteristics? Last, but certainly not least, the bill's so-called protection of religious exercise is completely illusory. The protection of religious exercise provision in the bill merely restates a constitutional test that already exists. It does not create any exception or otherwise shield religious schools, faith-based charities, or small religious employers from the expense and uncertainty of litigation. The bill expands the definition of the term employer to explicitly capture religious organizations. So on one hand, we are told that religious liberty is protected. On the other, religious institutions are brought within the scope of liability for claims based on sexual orientation and gender identity. For these reasons and others, I cannot support House Bill 300 and urge its defeat today. Thank you.
Are there any other comments on the bill? Representative Borowitz, you are in order to discuss the bill.
Thank you, Chairman. Representative Benham and Representative Kenyatta, can you tell me how many genders there are?
Representative, why don't you discuss the bill? I don't know if
It's a question for the sponsors of the bill. They're adding in gender identity. I would like to know how many genders they believe there are. That would be added into Pennsylvania law. I think that that's a serious question.
Mr. Chairman, a point of order.
You're in order.
So when a member, first and foremost, wants to address another member, it's my understanding that we address them by their titles or by their districts, but we do not speak to them as if we are friends on a playground, A. And also, in addition to that point of order, Mr. Chairman, in terms of interrogating other members, can you talk about what our rules say about the process of doing that in committee or on the floor? Is it just to scream at members through their microphone?
So decorum is respected in committee as it is on the floor. So you're right on that. And interrogation is something that is agreed to on the floor if you want to participate, as it is here. So I recognized you to discuss the bill. I didn't recognize you to ask questions on the bill. If someone would like to answer that, I'm not going to get in the way, but I would prefer that you just make comments on the bill.
Thank you, Mr. Chairman. So as in a Pennsylvania House committee, Judiciary Committee, people that are proposing a bill to add gender identity can explain to me and answer a simple question of how many genders they believe there are. I mean, I'm sorry. I mean, this is a constitutional republic. I think when they're adding into legislation
Chairman, a point of
gender
order.
identity, we should be able to ask the
Representative
question, how
Kenyatta.
many genders does Representative
Borowitz, can
Kenyatta
you
from
pause?
Philadelphia believe that there are? That's a legitimate question. I think Pennsylvanians deserve to know.
Representative Kenyatta, point of order.
Thank you, Mr. Chairman. So I guess, again, I'm referencing our rules, which hopefully in addition to the bill, the good lady has read those rules. Is she asking to interrogate either of the members of the bill? Is she speaking extemporaneously, free flow of thought? I just want to understand what she's doing, but
Thank you, Chairman, and thank you, Representative Kenyatta. I would just simply like to know in your legislation, when you explain gender identity as the sponsor of that bill, how many genders do you believe there are?
Mr. Chairman,
it's a pretty
again, as
simple
a point of
question.
order,
It's a pretty simple question.
Mr. Chairman, as a point of order, the gentlelady has yet to ask either member if they would like to stand for interrogation, and again continues to engage in this sort of rhetorical Pollock-esque
Thank you,
random
Okay,
scattershot.
Chairman,
we-
does
we
this
all-
not
we all have to
pertain
get
to the bill?
focused.
Does this not pertain to the bill? I'm not sure how this doesn't pertain. It is not germane to the bill. This is germane to the bill. This is a question about the bill. But
Mr.
it
Chairman, again
sounds-
on a point of order,
Okay,
this is not
if everyone could
question
just
about
take a
germaneness.
breath. We're not going to go back and forth, both members. Representative Borowitz, if you have a question, you direct the question to the chairman of the committee. If someone is interested in answering it, which you were not recognized for interrogation, you were recognized to speak on the bill. I don't think we were going to go back and forth with answering your questions, so just speak on the bill.
So it sounds like, since no one wants to answer the sponsors of the bill, a simple question of genders, I'll answer it again, once again, like I did with the pro-life bills, right? There's two genders, right? And if we want to speak of Christian faith, God created us male, which is my faith, in Jesus, is male and female. You do not get to redefine gender and then demand we have to respect that ideology or face civil charges and eventually criminal charges that we're seeing all over in England, Australia, people being arrested. And I have 9 pages here of examples of actual lawsuits and cases that are currently or have been taken into court dealing with sports. And these are real examples. So we have transgender fighter Fallon Fox broke her opponent's skull in an MMA fight. We have Leah Thomas, quote Leah Thomas, who broke a woman's records, who was nominated for NCAA Woman of the Year and exposed himself to women in a locker room. This is what House Bill 300 would do. Female volleyball player testifies to physical mental trauma since injury by trans athlete. So all of this bill would be basically make it a hate crime, or we would not be allowed to speak out against this. Okay, let's move on. I won't go through all of them, but here we have pronouns. This is the teachers that have been fired because they were unwilling. When we want to talk about discrimination, it seems like there's 9 pages of discrimination, right? Of teachers that have been fired for not being willing to use pronouns. Let's just give a few. A Catholic mom in Northern California enrolled her daughter in a public charter school. And during her initial Zoom classes, this girl, an incoming freshman who had not yet set foot in the school due to COVID, was asked her name and preferred pronouns. She chose a male name and male pronouns. The school then used this information without informing her parents. Virginia teacher Peter fired after refusing to use a transgender student's pronouns. I could go on and on of examples of discrimination against those who hold religious beliefs and are being discriminated against, if we want to talk about discrimination. This is a very dangerous bill. It's a perversion of God's creation.
Any other comments or questions on the bill? Representative Pielli.
Thank you, Mr. Chairman. I've listened attentively to arguments regarding this bill over the years. I fail to see how this bill has included boys playing and girls sports in high school, and the litany of horrible things that have just been cited by both Chairman Coffin and my other esteemed colleague have happened without the introduction and the passing of this bill. This bill has nothing to do with it. At its core, it's simply extending the rights and the protections we all enjoy to our LGBTQ citizens. There are doctors, there are lawyers, there are police and firefighters, there are soldiers, there are neighbors, there are colleagues who we work with, and they're even family. And what the difference is that if you are part of this community, you do face discrimination. That's what's different. I don't face that discrimination, but I'm trying to have empathy and understand when I see this type of discrimination, and we try to right wrongs as best as we can, although we're imperfect. I guarantee everyone on this dais knows a person of the LGBT community. 30 years ago, as a soldier, when I served under Sergeant Turpak, probably the greatest soldier I've ever served under, who time and time again would put his life and limb on the line for the service of our country. It was during the time of don't ask, don't tell. And Sergeant Turpak was never asked and he never told, but he suffered in silence. And I remember discussing with him an article from the late, and for some people, great Senator Barry Goldwater, when he was asked about what he thought about gays in the military. And he said, I don't care if they're straight, as long as they shoot straight. If we go 15 years or so forward, I remember my 2 children apprehensively waiting for me as I came home from work. They were scared. They had something to tell me. And they didn't know how I would react. And both of them came out to me saying that they were gay. I didn't know what to think at first, but I took a step back and I chose acceptance and love. And I understood that their way was not going to be an easy way. Their way was going to be a harder way. Now, I've heard some of our colleagues discuss God. With all due respect, as a Christian myself and as a person who's proud to serve in this august body founded by the principles of William Penn, I respectfully ask you to worship your God in your way, and I'll worship it in mine. And I choose a loving and accepting God, the God of inclusion. As such, I'm going to vote accordingly for yes on this bill to afford the rights and liberties that we all enjoy to our brothers and sisters in the LGBTQ community. Thank you, Mr. Chairman.
Thank you. Any other comments on the bill? Representative Kale, you're in order to discuss the bill.
Thank you, Mr. Chairman. And out of the gates, I would like to say to the co-prime sponsors of these bills, I recognize that your sincerity in bringing these, your passion for these issues, and the passion you bring to it is admirable. I think Chairman Frankel also has been discussing this issue for a number of years, since I've been in the legislature, and the persistence and the resilience is something to be admired. Unfortunately, in my estimation, passion can be misguided, and in this case, that is the instance. We talked a little bit about what this bill is not and what it's supposed to be doing. However, and unfortunately, we've had examples of what can happen with these types of bills from across the nation. We could say, well, no, it's not going to be applied like that. But at the end of the day, what we say in these committee meetings don't mean much. Legislative intent, as far as I know, has not been a very serious consideration of any court in the Commonwealth of Pennsylvania, especially when you have language that says something different. It's important to actually look, instead of just say, well, this is how it will be applied and this is how it won't be applied, to look at examples from around the country to see how it actually is applied, how similar bills are applied. And I have a couple of, I wanted to ask a couple of questions, Mr. Chairman, but if you would prefer that I just address the bill, I'm happy to defer to that.
No questions allowed.
It
But
depends on what kind of, if it's questions the council on the actual bill, then we'll entertain that. But
it is questions on the bill, and I would just address it to you, Mr. Chairman, and you could go from there. HB 300, as applied, would it require medical providers, a doctor, or a medical facility to perform a gender reassignment procedure?
council, you want to take a swing at that?
Yes, Mr. Chairman, thank you. The Human Relations Act does not pertain to medical professionals. Thank you.
Thank you.
And the reason I ask is because there's a very similar bill that was passed in California, and that really didn't answer the question. It wasn't a direct answer to the question. But there was a similar bill passed in California where
Mr. Chairman.
a hospital.
Is that point of order?
I just want to respond with one word to the question being asked. The answer to your question is no. And then if you want to restate it a different way, it would also be no.
Representative Carroll.
Thank you. I appreciate the clarity and the answer on that question. But unfortunately, a bill that has very similar language, it was passed in California, was applied by a court to force a Catholic hospital to perform a surgery it did not want to perform. I know that this was brought up a couple of years ago as well, and I think it's important to bring up again. And the reason why is because the landscape for doctors in particular, and there are other reasons to oppose this bill, but for doctors in particular in this area has been changing dramatically. You have doctors getting sued for performing these surgeries, not because they negligently performed them, but because they did in fact perform them when it didn't seem as though it was the right thing to do. So imagine for a moment that you're a doctor and you could potentially get sued for not doing the surgery, and you could potentially get sued for performing the surgery. It is a very strange predicament for anybody in the medical profession to be in. On top of that, the medical profession on this issue in particular is changing. The American Medical Association has come out on certain surgeries of people of under a certain age and raised questions as to whether or not it's something that should be done at all. And here we are in Harrisburg making determinations via legislation that that's what a doctor should do. It puts medical professionals in a very, very awkward and difficult situation. Furthermore, as it relates to sports, again, we could say, no, this won't be applied to sports. But if you look at how these laws are applied in other states, it is, in fact, applied in that situation. And I appreciate the effort by the prime sponsors. I sincerely mean that. I appreciate the effort to protect vulnerable people. I think that is an honorable effort. But through this legislation, I'm concerned that you are creating more victims than you are protecting. And as a father of 5 daughters, this issue is very personal to me because my daughter deserves privacy. My daughter deserves safety. My daughter deserves to have a bathroom where she can be confident that a female is the only sex within that bathroom. So, Mr. Chairman, without belaboring points, for that reason and others, particularly those that the good chairman, Mr. Kaufman, addressed, I am opposed to this bill.
So we're going to go to a roll call, but before we do that, Representative Kenyatta has some closing remarks. Representative Kenyatta.
Thank you so much, Mr. Chairman. So for those who are following along at home, a lot of the debate, what you heard, good news for you, I sort of prepared you for what you would hear in this debate. So if folks are not aware, there's a rhetorical sort of argument that people also engage in. It's called a straw man argument. And so what people do in a straw man argument is they build up a weaker defense and then knock that down and then say, look, I gotcha. So we've seen a lot of that today, where opponents of this legislation have created opposition to things that are not in the bill. These things are not secretly in the bill. They are not being hidden somewhere in the language. All of the arguments we have heard, not a single one of them is present in House Bill 300. Now, what I care about is that we follow the rules of this committee, which I've said. But let me respond to some of the things that have been raised and be crystal clear. House Bill 300 does not relate to, in any way, sports in the Commonwealth of Pennsylvania. It does not secretly, it does not explicitly, it does not exist. So for those arguing that, they are putting up a straw man, which I have given you sort of some primer on what that is. Folks have talked about, again, bathrooms. Not in this legislation at all. And the good gentleman from Beaver County, who I have a lot of respect for, and I appreciate the way in which he shared his views on this legislation, but one thing he said really caught my eye. He said, if you're a doctor, I want you to imagine what this would mean. You would have to imagine, because you would be making it up. You would really have to go down an imaginary trail to think that this legislation, which does nothing as it relates to the medical practice of putting on a Band-Aid to anything else, that this would somehow impede the medical profession or impact the medical profession at all. It does not. The statute that we are simply adding a few words to does not even address a statute that is anywhere close in sniffing distance of any statute related to the medical profession here in Pennsylvania. So yet again, straw man has been built up that has nothing to do with the legislation. But I will end, Mr. Chairman, by making a point that actually furthers my resolve to get this bill passed. None of the opponents of this bill actually had opposition to what is written in the bill, which lets you know that the bill is just fine. Now, for all of the imaginary things that they've brought up, for this bill that they have brought up, yep, go ahead.
Point of order, isn't that motive, Chairman, then, for us? Isn't he's saying what we're making is making up? Point of order for us? But no, I guess that doesn't count.
Well, when the gentleman from Beaver County said that doctors would need to imagine, and I am now talking about the imaginary things that they might imagine, this is me continuing and responding to the good gentleman from Beaver County. And I will say to the gentlewoman from Clinton County, I am grateful that the despicable language that you used in this debate, including calling certain Pennsylvanians perverse, these are your words, madam.
Point of order.
These are your words, madam, and if you do not like me responding to your words, use different words. And also, you've not allowed me to finish, so you have no idea what I'm going to say.
Point of order.
So I would appreciate
Chairman,
the opportunity.
motive.
Madam, I know.
Representative
I appreciate
Kenyatta,
the opportunity to respond because I've not even
Representative
said
Kenyatta.
my statement. Yes, Mr. Chairman.
I am going to allow the representative to address her point of order.
Say that again, Chairman, I'm sorry.
Representative Borowitz, what is your point of order?
Yeah, a motive. I mean, he's literally saying my despicable comments. This is my held religious beliefs. I don't hate anyone. This is my strong held religious beliefs. And he's calling that despicable. How's that not? I mean, he can't even explain his bill, and he's trying to control the committee because he can't even explain a basic question I had on his bill.
Representative Borowitz,
and
I
now
allowed
he's
you.
calling my comments
I allowed you a
despicable,
lot of
that are
latitude
religious held
in your
beliefs.
remarks. Representative Kenyatta is offering closing remarks, and the sooner we get to roll call, I think the better for everyone. So, Representative Kenyatta, could you conclude?
Yes, thank you, Mr. Chairman. And I want to be clear on this point. I want to be very clear on this because nobody in this building has ownership over the Christian faith. I am a Christian. I am a Christian. And if folks understood how I grew up, I went to church overtime, double time. And so I'm not going to be lectured on the Christian faith. And to be clear, Mr. Chairman, I'm going to finish my comment because it was not disparaging the good lady from Clinton County. In her closing comments, she mentioned and referred to many Pennsylvanians who, in her view, she considered perverse. And what I was going to close to say is that I am happy that the gentlewoman is not a part of the microscopically small group of Pennsylvanians that she considers perverse, that she never has to be on the receiving end of people using their platform and position to disparage them in this way. I am happy that the protections that we're trying to extend in this bill are protections that feel so foreign to the good lady of Clinton County because she has never had to endure people coming to a building debating their right to exist. I mean it genuinely. I'm happy that she has not had that experience. But there are millions of Pennsylvanians who know through a variety of different distinctions that they hold what it means to be treated differently and what it means to hear politicians refer to them with language that is despicable. And I think that language of calling people perverse is despicable. And I want to say one final thing about faith because we keep talking about it. Depending on what version of the Bible you use, the King James, I think you get about 319 in terms of the time the Bible uses the word love. If you use the NIV version like I do, you can get upwards of 517 instances of the Bible using the word love. It uses the words gay 0 times. 0 times. And so if we want to talk about the Christian faith, I want people to understand what it really looks like to practice your faith in a way that doesn't disparage others, but that lifts them up. That lifts them up. We have an opportunity to treat everybody with respect. That's what the Fairness Act is about, and that's why I'm going to be voting yes, and why I think a majority of Pennsylvanians want us to do the same. Thank you, Mr. Chairman.
Thank you, Representative. And at risk of a commitment, Representative Kale is going to be very brief, and then we're going to go to roll call.
It's going to be very brief, Mr. Chairman. I am pleased to hear the prime sponsor of this bill say that this is not about sports, that this is not about hospitals. Unfortunately, how these bills have been applied, practice says something different. But there is a very simple solution to all of this. We have the language, make an amendment, add it to this bill. Put the fairness in sports in this bill. If you said that men will not be playing in women's sports, put the language in the bill.
You could have done that. Secretary, please call the roll.
Thank you.
All Democrats will be yes.
And all Republicans will be no.
Thank you. This bill passes a vote of 14 to 12.
We will be reported as committed. Congratulations, representatives. Next on the agenda will be House Bill 632 by Representative Waxman. Representative Waxman has joined us today. You will be recognized for brief remarks once you get to your seat. Thank you, Representative Waxman.
Hi, good morning, and just thank you so much to the committee, to the chair for taking this bill up. We did do a hearing on this bill a few months ago, so I don't have a tremendous amount to add. It removes the sentencing enhancements in Section 5902 of the Criminal Code for individuals living with HIV and AIDS. This bill is designed to strip the mention of HIV out of our criminal code as a potential enhancement, felony enhancement. So. But I urge a yes vote, and I just thank again for the time and the committee willingness to consider it.
Thank you, Representative. Council, is there anything to add on the bill?
Yes, Mr. Chairman, briefly, thank you. House Bill 632 also provides a procedural avenue for relief to individuals who've had a sentence for prostitution enhanced based on their status as someone living with HIV or AIDS. The public hearing that the maker of the bill referenced was held publicly here on June 2nd, 2025, on this bill and decriminalizing HIV in Pennsylvania in general, where we heard from numerous experts and received overwhelming support for this legislation. This bill takes effect in 60 days, and there are no amendments. Thank you, Mr. Chairman.
Thank you, Council. The question is, will the committee report the bill? Are there any comments on the bill? Chairman Kaufman, you're in order to discuss the bill.
Thank you, Mr. Chairman. Everyone in this committee believes that those living with HIV deserve dignity and access to treatment without discrimination. That is certainly not in dispute. However, compassion for those living with HIV and protection for innocent victims are not mutually exclusive. My issue with this bill is that it frames criminal accountability for intentionally or knowingly exposing another person to HIV as inherently unjust. It characterizes such conduct as a form of discrimination. However, our criminal laws do not punish status. They punish conduct. More specifically, they punish conduct undertaken with knowledge that it places another person at risk of harm. When an individual knows he or she carries a serious communicable disease and deliberately exposes another person without consent while committing a crime, the law is not punishing that person because of a medical diagnosis. It is responding to a conscious decision to endanger someone else. This bill suggests that holding someone accountable for knowingly exposing another to HIV is equivalent to punishing someone simply for living with HIV. That is not accurate. There is obviously a significant difference between living with a serious medical condition and intentionally or knowingly exposing others to that condition. There have, in fact, been several instances in recent years where a prostitute has infected a client with HIV. In New York, a male prostitute who was also an illegal alien knowingly infected a client with HIV in 2023. The same thing occurred in a recent case in Michigan. The co-sponsor memo states that enforcement of prostitution laws is a law enforcement priority for most Pennsylvania law enforcement agencies. This is not supported by evidence. According to the Sentencing Commission, there hasn't been a single person convicted of a heightened prostitution penalty for being HIV positive in the past 10 years. Not one. The bill would allow courts to effectively resentence individuals who were previously convicted of this offense, which again all occurred over 10 years ago. These individuals have all completed their sentences. How exactly does a court resentence someone who has already completed their sentence? That is not how our criminal justice system operates. Once a defendant has completed their sentence, the court's jurisdiction over that case is exhausted. At that point, there is no ongoing punishment to modify, shorten, or correct. This provision is also clearly unconstitutional. The Pennsylvania Supreme Court has explicitly stated that the General Assembly cannot order courts to reopen final judgments. In Commonwealth v. Sutley, the court stated that the legislature cannot issue a command to the courts to open a judgment previously made final and substitute for that judgment a disposition of the matter in accordance with the subsequently expressed legislative will. The vesting in the legislature of the power to alter final judgments would be repugnant to our concept of the separation of the three branches of government. This is exactly what this bill would do. For these reasons and others, I will be opposing House Bill 632. I am, however, open to supporting an amended version of this bill that replaces references to HIV and AIDS with any communicable disease. Thank you, Mr. Chairman.
Thank you. Representative Kincaid on the bill.
Thank you, Mr. Chairman. I want to talk a little bit about the knowingly aspect of this, because when we are talking about charging someone for knowingly doing something, it means that they had knowledge of their condition. That's it. That's the threshold to be able to charge someone for knowingly exposing someone to HIV, which means that if you are aware of your diagnosis, you can be charged. And it does not take into account the fact that modern medications for HIV effectively make transmission of HIV between individuals non-existent. When you are well managed in your condition on modern medicine, you lower your viral load to a point where it cannot be transmitted. However, under this statute, you still could be charged, even if there was no possible way that the person who was exposed to your bodily fluids could have contracted it based on the viral load. So we need to keep up with medicine. We need to keep up with how things change. We put this legislation into place at a time when HIV was effectively a death sentence. It's not anymore. It is not something that is so dangerous that we have to hold people to an additional level of accountability. No, we don't want people to have long-term communicable diseases, but we also have to recognize where science has led us and that we are on the cusp of an AIDS-free generation because of modern medicine, because we have the technology in medicine to be able to prevent the transmission of HIV. So I think that that's a really important thing. The other aspect of this that the good chairman brought up is that no one has been charged in 10 years. This statute is not being used. So we don't need it. Our law enforcement doesn't seem to need this as a way of holding people accountable. So removing this from our criminal code impacts nothing because we are not seeing a significant need for this. Because I think our law enforcement also recognizes that modern medicine has protected them from exposure. And to the final point about case law that prevents this legislature from going back and resentencing folks. I think what is really important to understand about that case is that it was talking about the actual specific decision-making that the legislature is deciding on behalf of the judiciary what it is that the new sentence needs to be. That's not the case here. This is saying that these people are entitled to request a resentencing. If you've already completed your sentence, then you are not eligible for a resentencing. That's how that works. And it's unfortunate for anybody who might have been eligible that they completed a sentence that might have been lessened if this was in place, but it's not available to them. But for anybody who would be, and again, it seems that nobody would be, it doesn't actually matter then, because there's nobody who would be applying for this resentencing if we don't have anybody currently serving a sentence for this crime. So again, we are making a mountain out of a molehill, and fundamentally, it's really not even a molehill. It's just flat because there's nothing there. So taking this out of the criminal code costs us nothing, and it acknowledges modern science. So I would strongly encourage a yes vote because this is just cleaning up our criminal code with a statute, removing a statute that is no longer in use. And that's fundamentally where it stands. Thank you, Mr. Chairman.
Thank you, Representative. Representative Kenyatta on the bill.
Thank you so much, Mr. Chairman. I'll be very brief. I want to thank the gentlelady from Allegheny County and associate myself with all the comments that she just made, and thank the sponsor, gentleman from Philadelphia, for this. In previous sessions, I've carried legislation very similar to this, and I'm just so happy to see him pick up this baton and advance this with a real level of passion, with understanding of the reality in Pennsylvania and of the need, as was mentioned, to clean up our code and to reflect the medical reality of where we are. So, Representative Waxman, I just want to thank you for this legislation. Look forward to voting for it today.
Thank you. Seeing no further debate, Secretary, please call the roll. All Democrats will be yes.
And all Republicans in the no.
Thank you. House Bill 632 passes a vote of 14 to 12.
House Bill 632 passes and will be reported as committed. We're going to go a little bit out of order, just so Representative Waxman isn't here for the rest of the afternoon. I'm going to be calling up House Resolution 393. The chair will, if Representative Waxman has brief remarks on the resolution, and then we'll go to council. Representative, you're in order.
Thank you so much, and thank you for calling this up. The resolution just acknowledges sort of a national movement all over the country to try to decriminalize HIV from the criminal code, and it marks that day in Pennsylvania. Thank you.
Great. Thank you. Representative Council, anything to add?
Mr. Chairman, House Resolution 393 designates February 28th, 2026 as HIV is not a crime awareness day in Pennsylvania.
So we missed it. Sorry.
Forward to next year.
That is awesome. It's awesome. We haven't been here in a little bit. So thank you, Council. Question is, will the committee report the resolution? I'm going to recognize Representative Chairman Kaufman on remarks on the resolution.
Thank you. I'll be brief. Like House Bill 632, this resolution suggests that holding someone accountable for knowingly exposing another to HIV is equivalent to punishing someone simply for living with HIV. Again, there is a significant difference between living with a serious medical condition and intentionally or knowingly exposing others to that condition. if you read this resolution, it suggests that police and prosecutors target minorities when enforcing HIV criminalization laws. It claims, without citing any evidence, that these laws have been disproportionately used to prosecute people of color. This is demonstrably false here in Pennsylvania. There is one criminal offense in PA that explicitly references HIV or AIDS, and that's the offense of prostitution. Since its enactment, there have been 6 total convictions for HIV-related prostitution. Of these 6 convictions, which occurred over 10 years ago, 4 of the defendants were white. So again, I challenge the premise of the resolution and attempting to attack law enforcement within this resolution, and I will be opposing the resolution. Thank you.
Secretary, please call the roll on House Resolution 393. I encourage all members to be voting yes.
Chairman Briggs,
You know what, all Democrats will be yes. I'm sorry. Try to speed this up.
And all Republicans are no.
thank you. House Resolution 393 passes a vote of 14 to 12.
House Resolution 393 passes and will be reported as committed. Thank you, Representative Waxman, for joining us.
Thank you so much, Chairman. Thank you.
Next on the agenda is, I will call up House Bill 1311 by Representative Sanchez, great member of the committee. I will recognize Representative Sanchez for brief remarks before we go to council. Representative Sanchez, you are in order.
Thank you, Chairman Briggs. Chairman, in homicide cases, if a defendant was seriously provoked by the victim, conduct which might otherwise constitute murder may result in a lesser conviction for voluntary manslaughter. Serious provocation is defined as conduct sufficient to excite an intense passion in a reasonable person. Unfortunately, defendants sometimes prevail in arguing that a reasonable person would be so panicked after discovering a victim's LGBTQ+ status that their killing could not possibly meet the legal definition of murder. In a 2020 study, Professor Anderson of St. Edward's University found that Pennsylvania came in 3rd in all of the United States in the number of cases where this defense tactic is used. And by the way, between 1970 and 2020, this defense tactic was used at least 104 times nationwide. And where successful, the so-called LGBTQ+ panic defense, or gay trans panic defense, results in a sentence of between 10 to 20 years for voluntary manslaughter, as opposed to a sentence of 40 years to life for murder. In cases where defendants are not acquitted under the LGBTQ+ panic defense, the jury may still deadlock because it's unable to shake the inherent homophobia or transphobia of the defense. When it comes to an LGBTQ+ victim's dignity, a hung jury and a mitigated sentence have the same effect. Both withhold justice from LGBTQ+ victims and send the message that an LGBTQ+ person's life is not equal to others under the law. It's also important to recognize that this insidious defense does not need to be successful to be dangerous. Every time a defendant presents a narrative of blaming LGBTQ+ individuals for violence they endure, including murder, they bolster the harmful stereotypes and justify alarming rates of anti-LGBTQ+ violence in the United States. This legislation makes clear that one's existence of a member of the LGBTQ+ family cannot form the basis for such a defense. And as we've discussed, all the panic defense does is allow homophobia and transphobia to have a home in the legal system. It perpetuates the already rampant hate-based abuse toward the LGBTQ+ community as if their mere existence is reason enough to hurt or kill them. In closing, I want to thank Chairman Briggs for running this bill for this second consecutive session, and I hope we can join the 20 states plus the District of Columbia that already have laws on the books banning the use of this defense. Thank you, Mr. Chairman.
Thank you, Representative. Always great to be appreciated. Council, anything to add on the bill?
Yes, thank you, Mr. Chairman. House Bill 1311 by Representatives Sanchez and Schlossberg prohibits the use of the LGBTQ plus panic defense to murder by creating an explicit carve-out to the definition of serious provocation in Title 18, Chapter 23. This bill takes effect in 60 days, and there is one amendment.
Council, please provide a brief description of Amendment A02585.
Thank you, Mr. Chairman. This amendment clarifies that any nonviolent or non-threatening romantic advance cannot give rise to a finding of serious provocation. So it's just cleaning up the definition there. Thank you, Mr. Chairman.
Thank you, Council. The question is, will the committee adopt the amendment, Amendment A02585? Are there any comments on the amendment? Seeing none, I think this is a good clarification of the language. Secretary, please call the roll.
Chairman Briggs?
Yes. All Democrats will be yes.
Thank you.
And all Republicans, no.
Thank you. This amendment passes a vote of 14 to 12.
Thank you. Seeing question recurs. Are there any comments on the bill? Okay. The question recurs. Will the committee report the bill as amended? Amendment passes. We're on the amendment. The bill as amended. Question recurs. Will the committee report the bill as amended? Are there any comments on the bill? Chairman Kaufman.
Thank you, Mr. Chairman. On House Bill 1311, under Pennsylvania law, the concept of serious provocation reflects a longstanding recognition of human nature, that in certain highly charged circumstances, intense emotional events can affect how an otherwise reasonable person reacts in the moment. This doctrine is not an excuse for violence, nor does it absolve anyone of responsibility for their actions. Instead, it simply allows juries to consider the full context in which a confrontation occurred when determining the appropriate degree of criminal liability. Instead of trusting juries and courts to assess the facts presented to them, however, this bill attempts to predetermine which facts they are allowed to consider. This would establish a troubling precedent. It would tell courts and jurors that even if certain conduct occurred, and even if it contributed to the confrontation, they must pretend it did not happen. As amended, the bill explicitly states that an unwanted, nonviolent, or non-threatening sexual advance cannot constitute serious provocation. This categorical rule ignores situations where sexual advances occur in an aggressive or confrontational manner, where there is no threat of violence. In fact, in many circumstances, non-forcible sexual advances can actually be criminal, even though the advance didn't involve any threat. This is the reality of many, if not most, stalking and harassment victims. Instead of allowing jurors to determine whether conduct was actually provocative, based on the unique facts and circumstances that existed at the time, this bill imposes a blanket legislative judgment that applies in every situation. It treats all cases the same, even though real-world cases involve vastly different circumstances, personal relationships, and behaviors. We should be very cautious about passing legislation that restricts the ability of juries to hear evidence and assess culpability. I will be opposing House Bill 1311 and urge all members to oppose it. Thank you.
Thank you. Representative Borowitz on the bill.
Thank you. You have mentioned, Representative, over and over LGBTQ+. Can you explain what the plus means?
He's not going to stand for interrogation, but I think if you Google it, it's pretty.
So we can't ask
general
questions
information.
anymore in the committee, Chairman? Is this now a new precedent that is being set? We can't ask questions about the bill? Because it does pertain to the bill. He stated it, I think, over 5 times. So is that the new precedent, so we're not allowed to ask questions pertaining to the bill?
It's not in the bill. So if you want to ask counsel something that's in the bill for your, but general information, we give you guys plenty of notice to like look at the bill, get your head around it, ask your counsel for information. So continue your remarks,
Got it.
please.
So no questions anymore on
Thank
any
you.
bills?
Representative Kincaid.
Got it.
Thank you, Mr. Chairman. There is no equivalent defense available to women when they are propositioned by men in a nonviolent or non-threatening manner. And I think that every woman in here has experienced a man making unwanted advances in various settings. And yet there is no actual defense that exists that if this woman were to kill this man, that would be something that would be relevant in and of itself to a defense. Certainly, if someone is stalking somebody or making threats or assaulting them in some capacity, there is a self-defense argument to be made, but there is no panic defense available for any other group of people that experience unwanted sexual advances. So why are we saying that a specific group of people who experience unwanted sexual advances from LGBTQIA+ community members are entitled to an extra defense when people in that community are far more likely to be the victims of violence than they are perpetrators? Just the same as women are far more likely to be the victims of violence from somebody who is making a sexual advance than they are to be perpetrators in an instance like that. So if that is not a defense that is available to everyone, then I don't see how we can claim that it is a legitimate defense for one single individual group of people and not say that that's discriminatory. I think that's the definition of discrimination. Thank you, Mr. Chairman.
Thank you, Representative. We'll recognize Representative Klunk on the bill.
Thank you, Mr. Chairman. I have a question for Council or the maker of the bill. When looking at this particular bill, this is amending Title 18 and Chapter 23 and the definition section in Chapter 23 for serious provocation. In looking at Title 18 and in Chapter 23, I don't see definitions anywhere for gender identity or expression or sexual orientation. What particular definitions will we be using for those particular words, since they aren't referenced anywhere in Title 18 or Chapter 23?
Council?
Thank you, Mr. Chairman. Those terms are not defined in the bill.
Thank you, Mr. Chairman. I'll conclude.
Secretary, please call the roll. All Democrats will be yes.
And all Republicans will be no.
Thank you. House Bill 1311 passes as amended, a vote of 14 to 12.
House Bill 1311 as amended passes and will be reported as amended. Next, the chair will call up House Bill 1315 by Representative Sanchez. Representative, you are recognized for brief remarks before we go to council for an explanation. Thank you.
Thank you, Mr. Chairman. The law governing legal name change procedures allows our courts to waive the publication requirement and seal the court file if the safety of the person seeking a name change is in jeopardy. This legislation builds on these existing protections by eliminating the notification requirement and by sealing name change files automatically if the individual requesting the name change is doing so to affirm their gender identity. In doing so, we are acknowledging the sobering reality that coming out as a transgender person is potentially dangerous, while recognizing and removing the costly barrier to name changes that disproportionately impact our LGBTQ+ community. Thank you, Mr. Chairman.
Thank you, Representative. Council, do you have anything to add on the bill?
Yes, Chairman, thank you. Briefly, records can be reopened by a court order upon, I'm sorry, House Bill 1315 has an additional provision that would allow courts to open the record upon a showing of good cause or at the request of the petitioner. This bill takes effect in 60 days, and there are no amendments. Thank you, Mr. Chairman.
Thank you, counsel. The question is, will the committee report the bill, House Bill 1315? Are there any comments on the bill? Chairman Kaufman, you are in order to discuss the bill.
Thank you, Mr. Chairman. On House Bill 1315, under current law, any individual seeking a name change must publish notice in 2 newspapers of general circulation. This requirement is not a meaningless technicality. It helps prevent fraud, it protects creditors and others with lawful claims, and ensures transparency in judicial proceedings. It also ensures that registered sex offenders cannot evade supervision or community awareness. A name change is not strictly a private matter. It affects contracts, debts, court records, business dealings, and much more. To be clear, this bill creates a new automatic exception to the public notice rule. If a petition requests a name change to conform to the petitioner's gender identity, the court shall waive publication and shall seal the file. In addition to eliminating public notice, the bill removes all judicial discretion. Why does this bill apply to only one category of petitioners? Victims of domestic violence often face real, documented threats of harm, as do stalking victims, human trafficking survivors, and witnesses who cooperate with law enforcement. They all confront genuine safety risks. Yet under this bill, they are not entitled to an automatic waiver of the notice requirement. Instead, we're creating this exception for only trans people, presumably people that are somehow more at risk than stalking victims and domestic violence survivors. Again, this bill begs the question, is a man's claim to be a woman sufficient without more to qualify for automatic sealing? Would a claim to be non-binary, two-spirits, pangender, or any other ever-expanding and ever entirely subjective categories qualify? What about gender fluid, which, as I understand it, involves gender identities that change from day to day? A Fort Bragg kindergarten teacher who identified as a transgender wolf recently made headlines. Would someone like to be entitled to relief under this legislation? The bill provides no definition of gender identity. There's absolutely no evidentiary standard. At a minimum, any legislation that mandates secrecy in court proceedings should contain clear definitions and objective standards. The bill contains neither. Under current law, notice must also be given to any non-petitioning parent whose child, their name, may be affected. But this bill requires the court to waive the entire notice requirement for that child when the petition is based on gender identity. That means if a minor petitions for a name change under this provision, the court must waive notice to the child's parents and seal the file. As a result, a parent would receive no notice that his or her child obtained a judicial name change. Clearly, this is not a minor procedural adjustment. It is a significant departure from long-standing principles of parental notice and involvement in matters affecting a child's legal identity. Lastly, it's important to note that if there is a risk to the petitioner's safety, current law already provides courts with the discretion to waive the public notice requirement. I will be opposing and urge all to oppose House Bill 1315.
Thank you, Representative. Representative Hohenstein, you're recognized on the bill.
Thank you, Chair, and thank you to the representative from Montgomery County for presenting this bill. I will reference the fact that my child spoke out on exactly this concept and on this bill a few years ago. I'll do what I usually do when this bill comes up regarding name changes and why it is important for someone to be able to control their own personal record and how they present themselves out into the world. I'll probably put that video up again. It seems to be one of the most popular ones that I have, probably because my kid is a much better spokesperson for these issues than I am. But I do want to say this about the concept of protecting people who are in the trans community in particular. And it's been brought up in a couple of the other conversations that we've had today. My belief is when we take steps like we've taken with HB 300 already, and that we're taking now with some of the other bills that have been presented, what we're recognizing is not so much an issue or a fact that separates us, but rather we're recognizing a common humanity that exists for all people. And we are recognizing that we as a society have not always recognized that common humanity, and so we need to provide the legislation that will allow smaller, more vulnerable groups like the LGBTQ plus community generally, and especially like the trans community, which is even a smaller slice of our population. For my part, I will always be here for communities that don't have a voice, that have historically been set aside, put on the margins, and placed in danger simply because of who they are. And I will always protect people from that community. And again, I will be a yes on this and appreciate the representative for bringing it forward once again.
Thank you, Representative. Secretary, please call the roll.
Chairman Briggs?
Yes.
Representatives Abney? Carroll? Donahue? Hanbidge? Hohenstein? Howard? Kenyatta? Kincaid? Mays? Pielli? Rab? Sanchez?
Yes.
Schusterman? Chairman Kaufman?
No.
Representatives Bonner?
Designation no.
Borowitz? Ham?
No.
Kale?
Designation no.
Kerwin?
Designation no.
Clunk? Kuzma?
Designation no.
Ledbetter?
Designation no.
Pugh?
Designation no.
Rigby?
Designation no.
Shalaba?
Designation no.
Mr. Chairman, this bill passes a vote of 14 to 12.
Thank you, Secretary. House Bill 1315 passes and will be reported as committed. Good job, Representative Sanchez. Next on the agenda, I will be calling up House Bill 1800 by Representative Kenyatta. I will recognize Representative Kenyatta for remarks on this important bill. You are in order.
Thank you, Mr. Chairman. On February the 4th, 2022, best day of my life, I got to stand across from my husband in front of my pastor, that time my fiance, and have him become my husband. So many Pennsylvanians and Americans have had the joy of doing just that, of marrying the person that they love. And thankfully, a number of years ago, the Supreme Court ruled, a majority decision, that beautiful process of two consenting adults joining their lives was available to everybody. But unfortunately, Pennsylvania statutes have not kept up with the good jurists from the District of Columbia. So we have an opportunity to do today what we did in the last session, which was to pass this cleanup of our statute with bipartisan support, and I hope that we do so again today. So thank you, Mr. Chairman.
Thank you, Representative, and congratulations. Council, anything to add?
Mr. Chairman, House Bill 1800 repeals Section 1704 of Title 23 that limits marriage to one man and one woman and replaces it with a definition of marriage as a civil contract between two individuals. The bill takes effect immediately, and there are no amendments.
Thank you, Council. The question is, will the committee report the bill, House Bill 1800? I'm going to first go to Chairman Kaufman.
Thank you, Mr. Chairman. As drafted, House Bill 1800 defines marriage to be a civil contract between two individuals. And this definition isn't just incomplete, it's legally incoherent. If marriage is nothing more than a civil contract between two individuals, then a lease agreement could constitute a marriage. Gym memberships and cell phone contracts would be marriages. There are civil contracts between two individuals, yet no person should seriously contend that signing a lease makes a landlord and tenant spouses. Clearly, more work needs to be done on this bill, and if the Commonwealth is going to amend the definition of marriage to recognize same-sex marriages, we must do it with more precision, and with that, I cannot support House Bill 1800 today.
Representative Borowitz on the bill.
Thank you, Chairman. House Bill 1800 is trying to make the definition of marriage a civil contract between two individuals, but marriage is not a civil contract between two individuals. Marriage is a sacred covenant institution created by God between a man and a woman. Those that have agreed with me include Barack Obama. In 2008, said marriage is the union between a man and a woman. 2006, Joe Biden, defending the Defense of Marriage Act, said marriage is between a man and a woman, and states must respect that. This is not hate, though I'm sure the news media will portray it as that. This is the Judeo-Christian values and principles this nation is founded on. And marriage and family are one of those bedrocks. Thank you, Chairman.
Any other comments on the bill? Closing comments from Representative Kenyatta.
Thank you, Mr. Chairman. So on this, you actually have some agreement. Family is the bedrock of our society, and families that look in a variety of different ways deserve the same dignity and surety that their marriage is going to get the same respect that the Supreme Court has said we are all allowed. And I would also just say how much I enjoy the good gentlelady from Clinton County who now quotes President Barack Obama and President Joe Biden. If you come to the Judiciary Committee, you never know what could happen. So I'll keep showing up and look forward to us advancing this piece of legislation, doing so in a bipartisan way, and continuing to treat all Pennsylvanians with respect. And I would just make the point, in that beautiful ceremony I mentioned on February 4th, 2022, I was not asking, nor do countless other people get married, for the blessing of the gentlelady from Clinton County or anybody else. You weren't invited. We had a wonderful time, and we want the government out of our business. It's a pretty libertarian view, actually.
Thank you, Representative. I'm actually doing the math in my head. It's 5 years, right? 22? Or I'm sorry. I remember the post. I remember seeing it. I was disappointed I wasn't invited. But it was very, very exciting day for. We are going to do a roll call on this. I don't see any further debate. Secretary, please call the roll.
Chairman Briggs?
Yes.
Representatives Abney?
Designation, yes.
Carroll?
Designation, yes.
Donahue? Hanbidge?
Designation, yes.
Hohenstein? Yes. Howard?
Designation, yes.
Kenyatta? Yes. Kincaid?
Designation, yes. She stepped out.
Mays?
Designation, yes.
Pielli? Yes. Rab?
Designation, yes.
Sanchez?
Yes.
Schusterman?
Designation, yes.
Chairman Kaufman?
No.
Representatives Bonner?
Designation, yes.
Borowitz?
No.
Ham?
No.
Kale?
Designation, no.
Kerwin?
Designation, no.
Clunk? Kuzma?
Designation, no.
Ledbetter?
Designation, no.
Pugh?
Designation, yes.
Rigby?
Designation, no.
Shalaba?
Designation, no.
Mr. Chairman, this bill passes a vote of 16 to 10.
Thank you. Secretary, House Bill 1800 passes bipartisanly and will be reported as committed. Congratulations, Representative. And I encourage all members to come to the meetings because you never know what's going to happen. We were going to go to Representative Frankel. Next, the chair calls up House Bill 1902 by Representative Frankel. When you get to the table, you will be recognized for remarks on your bill. Always nice to see the chairman. And when you're ready, you can begin.
Thank you, Chairman Briggs, Chairman Kaufman. Chairman Briggs, thank you for bringing up these two companion bills together, so House Bill 1902 and 1905. And I'm going to offer my remarks briefly on both of them.
That would be great. Thank you,
In the
Representative.
interest of time. I think that all of you know that 5.5 years ago, an anti-Semitic gunman radicalized by conspiracy theories walked into a building that housed several Jewish congregations in my neighborhood and murdered anyone he could find. We cannot change the horrors of that day, the lives lost, or the sense of safety that was shattered. But we can take action to protect against future tragedies, to recognize the vulnerable groups that are targeted, provide victims with a civil cause of action, and to give our law enforcement the training and support they need to properly investigate, identify, and report hate crimes. So thank you for taking the time today to read these bills carefully. In crafting them, we worked with legislators from across the ideological spectrum. We also reached out to identity groups, religious leaders, law enforcement groups, and civil rights organizations. We looked at other statutes and the federal hate crimes laws. I can assure you that the bills before you protect free speech and religious liberty. Time has marched on since October 27, 2018, like it always does. The victims have long been buried, although their loved ones still hold them in their hearts. The perpetrator has been tried and convicted. What remains is our responsibility to act. By passing these bills, we can update our laws and take meaningful steps to better prevent and address hate crimes. And let me briefly address, I think, one of the questions that came up 2 years ago when this bill passed this committee. Folks would say that, crimes like assault and murder and vandalism are already illegal. Why do we need a statute like this? And the fact of the matter is that when these crimes are committed, and I'll give you an example, say somebody vandalizes a stop sign with random graffiti, how is that differentiated from somebody who paints a swastika on a church, a mosque, or a synagogue? The difference there is the fact that the crime that is being committed is not just against a person or a specific piece of property. It's about intimidating an entire community that identifies as a vulnerable community in particular, and to terrorize them and to make them feel unsafe. That's why we have a federal hate crime statute. That's why we have states that have them. 35 other states across this country have more robust statutes that are comparable to the one you'll be voting on today. So this is not something that is particularly unique. We're just looking to update our capacity to enable our communities to address what is becoming almost very unfortunately an increasing problem that's affecting so many groups across our state. Thanks so much.
Thank you, Chairman. Council, anything to add on the bill?
Yes, Mr. Chairman. House Bill 1902 by Representative Frankel and Nelson strengthens protections for hate-based intimidation and requires police training. The bill accomplishes this by changing the term ethnic intimidation to hate-based intimidation and expands the current protections to include ethnicity, ancestry, sex, gender identity, gender expression, sexual orientation, or disability of an individual or group of individuals. The bill also requires police to undergo biannual hate-based intimidation training. The bill takes effect in 60 days, and there is one Briggs Amendment.
Council, please provide a brief description on the awesome Briggs Amendment, Amendment 02582.
A02582 8.2 changes the construction section of the bill to protect all speech. This change is needed to avoid a constitutional challenge based on viewpoint discrimination and to avoid unintended consequences. Thank you, Mr. Chairman.
Thank you, counsel. The question is, will the committee adopt the amendment? Are there any comments on the amendment?
Yes, sir.
Representative Borowitz, you are in order on the amendment.
Okay, so this amendment, it says you're removing nothing in this section may be construed to prohibit, limit, or punish religiously motivated speech or conduct that is otherwise protected by the Constitution of the United States. And you're going to change it, if I'm correct here. It shall be construed to prohibit, limit, or otherwise punish a person in the free exercise or enjoyment of a right or privilege secured for the person by the Constitution of the laws. So you're taking out the religious aspect of it. Am I correct in that? Is that what your amendment's doing?
Mr. Chairman, under the amended language, the religious language is carried with that because we're broadly protecting all constitutional rights, not just religious rights.
Right, but removing that from the original intent, which it does talk about the constitutional rights, but specifically mentioning religious rights. And so you're removing that, and that's obviously on purpose because you're saying that's going to construe with the intent of the bill, which this would basically walk all over people's religious liberty. Try to. You can't because it's God-given, right? So that's a God-given right by William Penn. Not by William Penn, but that William Penn instituted in Pennsylvania. And so you guys are purposely taking that out, even though obviously we are grateful that it is in the First Amendment of the Constitution of the United States. But this is the basis, like I said, that William Penn founded this Commonwealth on religious liberty, and you're removing it and replacing it with enjoyment, enjoyment of a right. I just want Pennsylvanians to know that, once again.
Mr. Chairman, the amendment was drafted because of all amendments and all constitutional rights should be treated the same. So by putting in specific religion, it jeopardizes the bill being constitutional itself. So we did that in order to protect all constitutional rights, whether it's the first, whatever amendment you enjoy the most, you'll be protected under this amendment.
Thank you. It's much more inclusive, including religious rights. So, Secretary, please call the roll. All Democrats will be yes.
And all Republicans will be no.
Thank you. This amendment passes a vote of 14 to 12.
Great, thank you. Amendment passes. The question recurs, will the committee report the bill as amended? Are there any comments on the bill as amended? Chairman Kaufman.
Thank you. And in the interest of time, as it did Chairman Frankel from Allegheny County, I'm going to address both bills at the same time as they're...
You're in order on that. Thank you for that.
Okay. Let me begin by saying that acts of violence or intimidation motivated by hostility towards another person's skin color or background are reprehensible and should always be taken seriously. However, these bills raise serious concerns. When we legislate in the Crimes Code, precision matters. Criminal statutes must be clear enough for citizens to understand what the law requires or prohibits. Ambiguous terminology in criminal statutes creates uncertainty for defendants, for prosecutors, for juries, and for the courts. Under current law, the offense of ethnic intimidation applies when a crime is committed with malicious intent towards someone because of race, color, religion, or national origin. These categories share an important characteristic. They are objective and largely immutable. The bills before us would expand the list of protected classifications to include disability, gender identity, and gender expression. There is no definition for the term gender identity or expression. Unlike a person's race, ethnicity, or ancestry, an individual's gender identity can seemingly change day to day. Again, without any objective criteria, would a biological man's claim to be a woman be sufficient to establish protections under this bill? And what does it mean exactly to be disabled? Since disability isn't defined, would obesity establish standing? Would anxiety, depression, or mood disorders qualify? Would dyslexia or other learning disabilities? These are conditions that vary widely in severity and are often defined differently across medical and legal contexts. And what about temporary conditions? If someone commits an offense against a person who happens to be recovering from knee surgery or walking on crutches with a broken leg, would that person suddenly qualify as a member of a protected class under these bills? These are not trivial questions. In criminal law, where the liberty of individuals is at stake, definitions matter. If we intend to expand the scope of hate crime classifications, then we must, at a minimum, provide clear statutory definitions so that everyone understands exactly what the law covers. Without these definitions, we risk creating a statute where key terms are left open to interpretation, which would invite inconsistent enforcement and potential constitutional challenges. For these reasons, I oppose House Bill 1902 and 1905. Thank you, Mr. Chairman.
Thank you, Chairman. And I do think, if people are going to speak, they should speak on both bills now, and then we'll go straight to a roll call after the second one. Representative Borowitz on the bill.
Thank you, Chairman. Again, thank you for Chairman Kaufman, your words. There's no definition once again, and we can't ask a question. So you now see what happens with truth that gets marginalized in a committee. When you're asking honest questions, trying to get definitions of a bill that's going to be added in, gender identity, gender expression, there's no definition, and we can't even ask the question. So now you understand what it means to have the truth marginalized in a committee in the Pennsylvania State House. As evident as we've watched in the last, 45 minutes of trying to get a simple question answered of something that's going to be added into our law, and we can't even get a simple definition, and it's not even put in the bill as a definition. And now the Pennsylvania State Police, if this bill was signed by Governor Shapiro, would have to implement a plan of something we don't even have defined, and no one can even define it. Make that make sense. I'll end with, the further a society drifts from the truth, the more the people will be punished for speaking it. We're seeing this happen everywhere. We're seeing people have to fight lawsuits all the way to the Supreme Court of the United States for freedom of speech and freedom of religion from these things being shoved down our throats. And marginalizing the truth and speaking the truth in love. Speaking the truth in love. And love is speaking the truth to those that need it. Whether it's a parent speaking to their child and affirming them in the way God created them, or whether that's a teacher using the correct he or she in a classroom. That's their religious liberty and their right, and affirming and actually showing them who God created them to be. How are we here in this Pennsylvania, in this state, in this Commonwealth that William Penn founded on religious liberty, these bills that are coming forward this morning, and then being marginalized at a committee and you can't even ask a question? Outstanding. It's very sad, and it shows the state of our nation and the godlessness and the road that we've gone down incrementally, and now we're here. So thank you, Chairman, for letting me speak. I appreciate it.
You're welcome.
Thanks.
Representative Kenyatta on the bill as amended.
First of all, I want to thank the maker of the legislation, and it has been really interesting listening to this debate yet again, and listening to a member of this committee who has not been silenced once, who has said everything that they want to say, continue to pretend to be a victim. The only victimization that I think could have been possible is you're a victim to your own lexiconical limitations. You're not a victim. Nobody's being silenced. You've been able to say whatever you want to say.
Excuse me, Representative, if you could stick to the bill, I appreciate it. I'm sorry.
No, I appreciate it, Mr. Chairman. Thank you, because I was going down a path. I'm just listening to the tiniest violin, and it's hitting me at a frequency that is deeply grating. Many of us, to the good gentleman's point in opening this, remember the horror that took place at the Tree of Life Synagogue, which was a part of what sparked this legislation. And many of us remember being there as we're breaking ground on the center that's going to be there to talk about the horrors of anti-Semitism and of discrimination more broadly, and that's incredibly important. And it's also incredibly important that our laws and that our statutes are really prepared to meet the vicious hatred that can be inflicted upon members of our communities here in Pennsylvania for practicing their faith, for being who they are. And so this is something that is long past due. And I know, like many of the pieces of legislation here, the good gentleman from Allegheny County has been on the right side of history for a long time. I look forward to voting yes on this legislation to see it getting to the governor's desk. Thank you so much.
Thank you very much, Representative. So before we go to a vote, Chairman Frankel has requested to be recognized for very brief
Thank you,
closing
Chairman.
comments.
I'll just be very brief about this. Look, these definitions are well known. They're certainly well known by those who target these vulnerable groups. When you talk about targeting groups, what happened at the nightclub in Orlando, targeting the LGBTQ community, those people knew and were able to define who those victims were. So these, and by the way, as I said, with respect to hate crimes, 35 other states have similar language to this. And I would say when he talked about House Bill 300, the same thing. 21 other states have passed legislation providing those protections for people. So the sky hasn't fallen. You know, people haven't been victimized because of those laws. People have been protected because of these laws that that you're voting on right now, and others that have been talked about today. So I would just say I would hope that we could rise above some of the partisan discussion that has been here today and pass a piece of important legislation that is not breaking any new ground, that is basically replicating the law in other states. Thank you.
Thank you, Chairman, and I do thank you for your years of dedication on trying to get to today's point. We did pass it last session, and your advocacy and willingness to continue to talk about how to make this as good a bill as possible is appreciated. Secretary, please call the roll on House Bill 1902 as amended.
Chairman Briggs,
Yes.
Representatives Abney,
Designation yes.
Carroll,
Designation yes.
Donahue, Hanbidge,
Designation yes.
Hohenstein, Howard,
Designation yes.
Kenyatta, Kincaid,
Designation yes.
Mays,
Designation yes.
Pielli, Rab,
Designation yes.
Sanchez, Schusterman,
Designation yes.
Chairman Kaufman,
No.
Representatives Bonner,
Designation no.
Borowitz, Ham,
No.
Kale,
Designation no.
Kerwin,
Designation no.
Clunk, Kuzma,
Designation no.
Ledbetter,
Designation no.
Pugh,
Designation no.
Rigby,
Designation no.
Shalaba.
Designation no.
Mr. Chairman, this bill passes a vote of 14 to 12.
Thank you, Secretary. House Bill 1902 passes and will be reported as amended. As we agreed upon, we're going to fast track this vote. Council, please provide a description of House Bill. Chair calls up House Bill 1905 by Representative Frankel. Council, please provide a description.
Mr. Chairman, this bill is basically the same as the last bill minus the police training portion of the bill. The bill takes effect in 60 days. There was one amendment.
Please provide a brief description of Amendment A02583.
Just like the last amendment, it's the same exact language. It changes the construction section of the bill to protect all speech. Thank you, Mr. Chairman.
Thank you. The chair, I call up Amendment A02583. All Democrats will be yes on the amendment.
And all Republicans no.
Thank you. This amendment passes a vote of 14 to 12.
Thank you. The question recurs, will the committee report the bill as amended? If this secretary could call up the vote for Amendment 1905 as amended, all Democrats will be voting yes.
On the bill? As amended?
On the, I'm sorry, on the bill as amended,
Okay.
all Democrats
All
will be voting
Republicans
yes.
no.
Thank you. This bill
That's why
passes
you-
as
that's why
amended.
we were good partners.
14 to 12. Thank you.
Thank you very much. Congratulations, Chairman, for your good work. I'm going to add, under any other business, some housekeeping. I'll be calling up Senate Bill 9 for the purpose of a motion to re-refer the bill
Mr.
to the
Chairman.
Children and Youth Committee.
Mr. Chairman,
Yep.
I make a motion to report Senate Bill 9 as committed,
I'm calling up a motion to re-refer.
and I'm making a motion to report Senate Bill 9 as committed.
My motion was first.
I appeal the ruling of the chair.
We can take a vote.
Yeah, I guess we'll have to take a vote. So, motion to overrule the ruling of the chair. We'll do a roll call vote. All Democrats will be voting against the motion. All Democrats will be voting no on the chairman's motion.
And all Republicans will be voting yes.
Okay. The bill could be sent to many standing committees. A few months ago, it was referred to us. I believe the Children and Youth Committee is best positioned to consider this legislation. Are there any comments on the re-referral? The chair will recognize Chairman Kaufman.
Thank you, Mr. Chairman. As has been demonstrated in the agenda today, protecting our daughters and granddaughters in sports in the Commonwealth is of no priority to this committee or the House Democrat majority. This bill is being bounced around, so it does not have to be considered and voted on because this concept and this language is widely supported among all peoples, Republican, Democrats, and independents in our Commonwealth. So I wholeheartedly oppose bouncing this around again. I stand with my daughter and my 4 granddaughters and all those to come and all of our daughters and granddaughters as we want them to have a chance here in the Commonwealth. Thank you, Mr. Chairman.
Thank you. I'm going to recognize Chairwoman Klunk on the motion to re-refer the Children and Youth Committee. Chair Klunk, you're in order.
Thank you, Mr. Chairman. I've kind of lost track where this bill has gone. It's now in the Judiciary Committee. Look, I am a proud former athlete. I'm a proud Coach Kate to many little girls on my softball team. I'm a proud mom, and I will stand up every single day for my daughters, their teammates, their little girlfriends, because I was once that little girl who played. I know what the challenges are for our women and girls in sports when boys and men enter that space. Our little girls deserve a safe space to play, to grow as little girls, to learn leadership skills, to learn about themselves, to learn what they're capable of, what their challenges are, to learn about defeat and also winning.
Chairwoman, can I
Mr. Chairman, as the chairwoman of the Children and Youth Committee, if this is where we put it, I will gladly fight to bring up this bill. I will vote every single day to protect my daughters, to protect little girls in this Commonwealth. And you know what? That is what that committee does. It stands up for our children, and I will do that every single day. And I will vote yes if that bill comes up. And I hope Chairwoman McNeil brings this bill up. She is a proud softball player. When we play every single year in our softball game she plays, I know she has little granddaughters who I would love to see her stand up and protect. Thank you, Mr. Chairman. I would love to vote for this today, but it's coming to the Children and Youth Committee, and I can't wait to vote yes.
So that's great. I was just going to remind you that we're not discussing the substance of the bill, but on the motion to re-refer, and it sounds like it's going to be a bipartisan vote to send it to your committee. I will recognize Representative Borowitz on the motion to re-refer the bill to the Children and Youth Committee.
Mike's not on, sorry. I disagree with the motion to re-refer. Is this, what, the 5th time that Democrats have run this bill to another committee? How sad. They must be scared to defend women and protect women and to keep biological males out of women's sports. This is absurd. I read probably 4 instances of women being harmed. And so I disagree with the motion to re-refer. Once again, they're skirting, running a bill, like Chairman Kaufman said, that is, everyone wants this and wants to keep girls and women protected and safe. And so I disagree with the re-referral. Thank you, Chairman. This is common sense.
Thank you for being on point. Representative Kenyatta, same reminder, we are discussing the motion to re-refer the bill to the Children and Youth Committee, not the substance of the bill. Representative Kenyatta?
Thank you, Mr. Chairman, for re-referring this bill to a committee that can interrogate the merits of it and has the proper jurisdictional remit for dealing with this legislation. But I would highlight, as we re-refer, Mr. Chairman, that members who've spoken out so far have introduced a grand total of 0 pieces of legislation that would actually invest in girls' sports here in the Commonwealth. Maybe that's something we ought to do. And in terms of protecting women and girls, there are some files that you might want to read called the Epstein files, which a president that you voted for is in multiple times.
A little broad. I agree. Let's, if in the future, everyone's got to keep a little bit tighter. Any other comments on the motion to re-refer? Representative Ledbetter, on the motion to re-refer, reminder to keep it to the motion and not the substance.
Thank you, Mr. Chairman. Mr. Chairman, I oppose the motion to re-refer Senate Bill 8. Girls across the Commonwealth of Pennsylvania do not need us as a body to find a new committee. They need us to find the courage to vote.
Thank you. Representative Ham, on the motion to re-refer, and reminder, not the substance of Senate Bill 9.
Thank you, Mr. Chairman. I oppose the re-referral of Senate Bill 9. You know, when you brought it up, the first thing that crossed my mind was, here we go again. Here we go again with the legislative tactics of avoiding voting on legislation that over 80% of Pennsylvanians agree with. This is insanity. It's insanity that we will not stand up for our little girls. I have 2 daughters, and it is pathetic that we cannot get this bill to a vote, and now moving it to a 5th committee where it'll sit until it has to be brought up and it'll be re-referred. Enough said.
Any other comments? Okay, so to be honest, I have 3 daughters, so I trump you on that, and they all do sports, and they're really good at it. But we were looking at this bill. We look at every bill. We're getting stakeholder feedback, and around a month ago, I was before the Health Committee for a bill to protect children from traumatic brain injuries. The majority chair of the Health Committee lectured me about protecting children, voting against my bill because, as she said, politics. My bill passed out of the Health Committee, and I want to thank Chairman Frankel for that. But her comments started making me think, in a fresh look at Senate Bill 9, she asked for movement of the bill. That's exactly what we're going to do today. She said this bill was about children, and I think today's motion to send it to the Children and Youth Committee will encourage that committee to take action that Representative Rapp was so adamant about. Therefore, I urge all the members to vote yes. Those in favor of re-referring Senate Bill 9 to the House Children and Youth Committee will vote aye. Those opposed to the re-referral will vote no. Secretary, please call the roll.
Chairman Briggs,
Yes.
Representatives Abney,
Designation yes.
Carroll,
Designation yes.
Donahue, Hambidge,
Designation yes.
Hohenstein, Howard,
Designation yes.
Kenyatta, Kincaid, Mays,
Designation yes.
Pielli, Rabb,
Designation yes.
Sanchez, Schusterman,
Designation yes.
Chairman Kaufman,
No.
Representatives Bonner,
Designation no.
Borowitz, Ham,
No.
Kale,
Designation no.
Kerwin,
Designation no.
Clunk, Kuzma,
Designation no.
Ledbetter? Pugh?
Designation no.
Rigby?
Designation no.
Shalaba?
Designation no.
Mr. Chairman, the motion to re-refer Senate Bill 9 to the House Children and Youth Committee passes a vote of 15 to 11.
Thank you, Secretary. In a bipartisan way, the motion to re-refer Senate Bill 9 to the Children and Youth Committee passes. For the information of the members, before we adjourn, we will be holding an informational meeting the first day back of session, March 23rd at 10:30 a.m. in this room. We're going to learn about the constable system in Pennsylvania. This meeting stands adjourned. Thank you, members.